non-existent judgments are also being cited. I think that also is a challenge for the courts also and the arbitrators also to see. And more responsibility, I think, on the lawyers also who are citing all these judgments. That's a big challenge we are all facing. The subjects are very important. I think we all go enriched with this conference, being the contemporary subjects. And I am thankful to the organizers for giving me an opportunity to share my little views on this subject. And I think this is all I can share, giving the time. Thank you. Jai Hind.
Thank you, my lord, for the profound words of wisdom. I now invite Honorable Mr. Justice Ehsanuddin Amanullah, Judge Supreme Court of India, to please share his lordship's thoughts with us on this special occasion.
Very good morning. Namaskar. Sat Sri Akal. Assalamu alaikum. I am very bad at taking names and remembering who all to address or not, so I think the shortest way is to address only the few dignitaries. Dr. Mohan Yadav, the Chief Minister of Madhya Pradesh, my esteemed senior colleague Justice Maheshwari, my colleagues Justice Bindal, Justice Arvind Kumar, Chief Justice Sajdeva, Madam Maria Sow, Learned Solicitor General, Justice Vivek Rusia, Justice Vivek Agarwal, and my brother and sister colleagues in the audience, my former dear sister, Justice Seema Kohli, Justice Gurish Kulkarni, brothers, sisters, students, men from the media. The gathering today is a little bit different from what we normally come to attend and what seminars are about. This is more of a thing which is now emerging on the horizon, and quite a lot of it is now relevant and has to be factored in, which probably in a country like India needs to be addressed at an early stage, given the volumes, the proportions, and the way India is emerging as a leader in all fields. I think rightly a decision has been taken, and I would also congratulate the team led by Justice Sajdeva to have conceptualized this type of a colloquium. The two-day collegium on evolving horizons, navigating complexities and innovations in commercial and arbitration laws in the digital world, which is a joint initiative of the Madhya Pradesh High Court, the Madhya Pradesh State Judicial Academy, and the Danish Patent and Trademark Office at Indore, is quite welcome at this stage of time. The world today is in a state of flux, if I may put it lightly, and this prevails across sectors, foreign, economic, trade, etc. The trappings of the office I hold prevent me from delving into this in detail, but if one were to look at it globally, the developments from a neutral perspective, one would be left with thinking to expect the unexpected. The legal profession is no exception to the global trends that are sweeping the globe today. The digitalization of economies has led to new forms of commerce, ranging from microfinance models to blockchain-based contracts to artificial intelligence-led supply chains. Such disruptions and innovations challenge the foundational assumptions that have conventionally guided contract law, including but not limited to its formalization, performance, and enforcement. As can be expected, when business and trade grow, commercial disputes increase. While Indian lawmakers have carried out reforms to the Arbitration and Conciliation Act 1996 and the Competition Act 2002, but they have also introduced now measures like the Commercial Courts Act 2015. Shifting gears, Europe a long time ago had witnessed the phase of lex mercantoria, or law follows the merchant, which phase, I am of the opinion, has returned inasmuch as regulatory authorities, judges, lawyers, and the like are scrambling to keep themselves ahead of the curve while also battling issues such as cross-border jurisdictional conflicts, enforcement of foreign orders, and connected matters. Insofar as the use of artificial intelligence and technology is concerned, with reference to the courts, the same is welcome. However, only to the extent that it aids the judge in determining matters. Preliminary stages of case processing and listing can and should be automated, but the judges and the human element in the act or art of judgment is what makes the system perform. An essential attribute of justice dispensation is that it must be tempered with mercy. In his 1990 book titled Power Shift, Knowledge, Wealth and Violence at the Edge of the 21st Century, Alvin Toffler has predicted that knowledge would come to rule the world. He had opined that in the fight between muscle, money and mind, ultimately the mind would prevail. In the present age, information is power. Simply put, knowledge of consumers and consumer habits is the new gold mine, and personal information has become a lucrative commodity, with business fighting to gain access to and utilize such data. The consequential fallout will entail privacy concerns. While the European Union and the General Data Protection Regulations, India has the Digital Personal Data Protection Act 2023. As we proceed, the interplay and overlap between such statutes and business interactions in the face of competing commercial freedom will require a tightrope walk to maintain delicate balance by all stakeholders involved, that is the courts, the regulators, the business community, as also the lawmakers. The integrity and fairness in the digital context does not only mean due adherence to an odi altum partum, but includes the right to digital inclusion. There must be adequate safeguard against algorithmic bias. This will become significant with the expected increase in online dispute resolution mechanisms, and there are many platforms already available which are offering technology-based resolution pathways for litigation, arbitration and mediation. We must also invest in capacity building, infrastructure development, and most importantly in digital literacy. The game and benefits cannot be allowed to remain to preserve of a few, but must be democratically shared with the whole populace. Humans have proven to be the most resilient of species, bearing in mind Charles Darwin's theory of survival of the fittest. In the long history of the world, even the fastest of changes are but a mere blip. When closer cooperation, solutions to the challenges that control us and to the ones which are likely to arise will surely be discovered or invented. As the adage goes, all good things to those who wait. The advantage I have of being among the last speakers is that I can say I humbly concur with what the speakers before me have said, and I hope to interact in greater detail during the course of the first session. I convey my special thanks to the organizing institutions, and I am looking forward to the deliberation and the musings that is ahead. I am sanguine that we will be left with more food for thought. Thank you and Jai Hind.
Thank you, my lord, for the enlightening address. I now have the privilege of requesting Honorable Mr. Justice Jitendra Kumar Maheshwari, Judge Supreme Court of India, to kindly deliver the inaugural address.
नमस्कार. इनिशियली आई वॉज थिंकिंग, सोच रहा था कि मैं भी कहूँ कि भाई आई शुड नॉट नेम। मैंने सोचा ये धृष्टता होगी अगर मैं ऐसा करूँगा, बिकॉज आई एम इन मध्य प्रदेश एट माई होम। I have to first respect everyone who is present here. Dr. Mohan Yadav, Honorable the Chief Minister of the State of Madhya Pradesh, Brother Justice Ehsanuddin Amanullah, Brother Justice Rajesh Bindal, Brother Justice Arvind Kumar, Judges of Supreme Court of India, Brother Justice Sanjeev Sachdeva, Chief Justice High Court of Madhya Pradesh, Brother Justice Vivek Rushia, Administrative Judge, Indore Bench, Justice Vivek Agrawal, Chairman and Governing Council of the State Judicial Academy, Ms. Maria Skau, Deputy Director General of the Danish Patent and Trademark Office, Mr. Tushar Mehta, Solicitor General of India, Justice Hima Kohli, former Judge, Supreme Court of India, Justice Girish Kulkarni, Judge, Bombay High Court, Honorable Judges and their gracious spouse present here, Additional Advocate General present from Jabalpur, Indore and Gwalior, Additional Solicitor General present here, Chairman, State Bar Council, Sir Adilal Gupta, President, Secretary of the Bar Association, learned senior advocate, advocates, judicial officers, esteemed academicians, our participant from Danish Patent, and dear students, gracious ladies and gentlemen. When I was looking about this topic and the speakers of today, at one end, Justice Arvind Kumar is with us. I have an occasion to sit with him. I know about his thought process and his eloquent ideas which have been come on floor. I think I need not to go more than that. When I think about technology, Justice Rajesh Bindal and Sanjeev Sachdeva is here, and I have an occasion to sit with Rajesh also. Then for technology, I need not to say much more. And when Amanullah is there, he is frequent visitor of everywhere. You can understand the ideas from every state across the India and globe also. But even when I was looking for this topic, I was seeing that international colloquium on evolving horizons, navigating complexity and innovation in commercial and arbitration law in the digital world. I try to interpret this topic. So when I was looking with two views, evolving horizon, navigating complexity and innovation, commercial and arbitration law in the digital world, not otherwise. Another part is, what are the evolving horizons to navigate the futuristic approach with respect to complexity and what innovation we have in our mind. And that is why the world which is growing on in these days, commercial and arbitration laws, how it can be dealt with in the digital era. So this is, and I feel the second thought process or second mindset may be a proper thinking for this colloquium. When we see this, we know laws are there, but it is required to be responded. And response is by the judgment, by way of discussion in colloquiums, by way of otherwise having expression for academicians. But the most and powerful tool is by way of judgment. We should not be reactive, but we should foresight the balance even at a stage of colloquium, even at a stage at a judgment, or even as an academicians. Though, whenever the academician thought of it, they always thought in one direction. The another academician thought in different direction. And it gives a space for discussion, and it gives a space for everyone and the thought process how we can give a response through judgment in the right perspective. Now we think on this, then we go by this aspect, then the real mean is our goal is therefore is not to reinvent the law, but to extend its principles with fairness, certainty in new domain. When we do this, we have some problems. Those problems come to the at present because the topic of today is in digital world, what we have to do, how we have to navigate all these issues. So when we go for this, then the question is of responsibility in the online ecosystem and how we can navigate first this. Then we have to think also the excessive control, risks, curbing innovation and expression simultaneously while we are having an excessive freedom, it may enable harm to everyone. Then in that situation, what we have to do? Now, in this regard, my thought process is in the same vein. The rise of digital marketplaces compels us to revisit the idea of fair competition. Today, dominance may arise not from ownership of the factories or land, but from control of data and algorithms. The invisible architecture of the online economy can entrench inequality as effectively as traditional monopoly. Our legal response must therefore safeguard transparency and equal access, ensuring the technological advantage does not translate into economic exclusion. Further, the necessity establishing a robust regulatory framework for these agencies is to ensure their functions and balance without oversighting any other thing. So this must be our thought process. We have seen the topics. There are a number of topics here. The discussion would be there. We see the time is running. So whenever my topic would be there, I will discuss in thorough. Here we have to conclude because Chief Minister has to go in a Prime Minister's video conferencing. So what I thought is, we have to think on so many aspects in session, but at the same time, we should have a promise of our technology must be vast, but it must always serve the same human ends and the life has long protected with dignity, fairness and trust. On this occasion of this inauguration of this conference, colloquium, I am grateful of High Court of Madhya Pradesh and the Judicial Academy for calling me and to be a part of this with all of you and to have a meet with giving an opportunity to meet all of you. Thank you very much.
Thank you, Lordship, for guiding us and highlighting the significance of commercial and technology law in today's world. With utmost humility, now I take the privilege to request Dr. Mohan Yadav, Honorable Chief Minister, State of Madhya Pradesh, to please deliver the keynote address.
विधि विशेषज्ञों की इस अंतर्राष्ट्रीय संगोष्ठी में अभी न्यायमूर्ति माननीय माहेश्वरी जी ने अपनी बात रखी। मैं उनका स्वागत करता हूं। इस अवसर पर न्यायमूर्ति माननीय अमानुल्लाह खां साहब, न्यायमूर्ति अरविंद कुमार जी, बिंदल जी, न्यायमूर्ति सुप्रीम कोर्ट और हमारे इस राज्य के अंदर इस पूरे आयोजन के सूत्रधार हमारे चीफ जस्टिस सचदेवा जी, आपका भी स्वागत है। अंतर्राष्ट्रीय स्तर से डेनमार्क से पधारी मारिया जी, माननीय रूसिया जी, विवेक जी, सॉलिसिटर जनरल माननीय तुषार मेहता जी, इस अवसर पर उपस्थित सभी समस्त देवियों सज्जनों, न्याय की बात हमारे देश से हजारों लाखों साल से एक अलग प्रकार से अपनी एक पहचान बनाती है और न्याय के किसी पक्ष पे बात करने के लिए विद्वत सभाओं का आयोजन किया जाना, ये भी हमारी अपनी शास्त्रार्थ की परंपरा से लगाकर कई कारणों से अलग अलग हर काल हर युग में बड़े सम्मान के साथ इसको देखा जाता था। और उसमें चार चांद तब लग जाते हैं कि जब विक्रमादित्य का राज्य वाला कोई मध्य प्रदेश जैसा राज्य हो, जहां न्याय की परंपरा 2000 साल पहले भी उस काल को आज भी गौरवान्वित करती दिखाई देती है। वो अद्भुत काल है जब हम अपने न्याय से, न्याय सिद्धांतों से, न्याय दृष्टांतों से, न्याय परंपरा से अपने आप को कहीं हम हरिश्चंद्र के समान उस काल तक भी पहुंचा देते हैं जब हम अपने किसी पक्षी को न्याय दिलाने के कारण से अपने मांस का भाग देकर भी मन में संतोष का भाव लाते हैं। ऐसे आज के इस बदलते दौर में वाकई ये मैं धन्यवाद देना चाहूँगा सचदेवा जी को और समूचे मंच को। आपने यद्यपि आज का इस समय बड़ा सबका कीमती है और कीमती समय में खास करके सुप्रीम कोर्ट से समय निकाल के आना, हमारे इस माँ अहिल्या की नगरी को गौरवान्वित करना, राज्य को गौरवान्वित करना, लेकिन सच में हमारे आपके माध्यम से ये बीता समय आज ये संगोष्ठी के आधार पर यूरोप के, डेनमार्क के विधि विशेषज्ञों के साथ हमारी उस गौरवशाली परंपरा में मैं तो एक और कारण से उज्जैन से भी जुड़ता हूँ। अमृत मंथन हमारे यहाँ होता आया था और ये अमृत मंथन की उस परंपरा में से जब विष को हटा करके हम जीवन रूपी अमृत पाते हैं तो अपने आप को भी गौरवान्वित करते हैं। आज के इस बदलते दौर में हम सब वहाँ खड़े हैं जहाँ की वास्तव में आवश्यकता है और कैसा समय बदला है। परमात्मा की कृपा, यशस्वी प्रधानमंत्री श्रीमान नरेंद्र मोदी जी का शासनकाल चल रहा है, जिस शासनकाल के माध्यम से हमारी न्याय की प्रक्रिया की, न्याय की व्यवस्था की सारी व्यवस्थाओं में हम अपने उस गौरवशाली अतीत से जोड़ करके देखते हैं। और सुप्रीम कोर्ट के लिए तो सच में मुझे तो धन्यवाद तब देता हूँ जब न्याय की देवी की पट्टी भी खोलने का सौभाग्य सुप्रीम कोर्ट के माध्यम से आया कि न्याय की देवी खुली आंखों से न्याय कर सकती है। आंखों पे पट्टी बांधना थोड़ा कहीं किसी को अच्छा लगे, किसी को बुरा लगे, लेकिन हमारे यहाँ तो पंचायतन पद्धति व्यवस्था में से अपने इसी स्थान पर बैठ करके न्याय की प्राचीन परंपरा थी। मैं धन्यवाद देना चाहता हूँ इस नाते से भी कि कितना अलग प्रकार का समय भी है। थोड़ा अटपटा जरूर लगेगा, मैं किसी विषय से इतर नहीं जा रहा हूं, लेकिन इसी इंदौर की नगरी का एक फैसला सुप्रीम कोर्ट से होता है साहबानो प्रकरण का, और कहीं प्रजातंत्र में एक छोटा सा दाग लगता, धब्बा लगता है। हमारी अपनी आंखों के सामने सुप्रीम कोर्ट के उस निर्णय को पुनर्परिभाषित करते हुए यशस्वी प्रधानमंत्री ने सुप्रीम कोर्ट की महत्ता बढ़ाई। ये हमारे लिए वर्तमान का न्याय का पथ वाकई गौरवान्वित होने वाला है। और एक और बात, जिस विषय को लेकर के समाज के अंदर अलग अलग प्रकार की धाराएं बहती थी और एक विषय, ज्वलंत विषय को टालने की जो परंपरा थी, उस टालने की परंपरा के बजाय सीना ठोक करके फैसला देना और दिए गए फैसले को लागू कराना और लागू करा करके दुनिया के अंदर भारत के प्रजातंत्र का मान बढ़ाना, अयोध्या जैसा फैसला भी करके सुप्रीम कोर्ट ने करके दिखाया। हम सबका सौभाग्य है। मैं बधाई देना चाहता हूं इस दायस को। जब हम संगोष्ठी की बात करते हैं तो हमको कमोवेश इन सारी तरफ से अपनी सारी बातों को विचार करते हुए इस विचार यात्रा को आगे बढ़ाने का मौका मिलता है। आज के इस अवसर पर मैं जब आपसे कोई बात कहने के लिए धृष्टता कर रहा हूं, यद्यपि मेरा दायरा सीमित है, मेरी अपनी मर्यादा भी है, लेकिन चूंकि यहाँ न्याय और न्याय की व्यवस्थाओं के आधार पर आज डिजिटल युग में, आर्टिफिशियल इंटेलिजेंस के समय में, ब्लॉकचेन के समय में, ऑनलाइन प्लेटफॉर्म, ऐसे कई सारे नए माध्यम और नए प्रकार हैं, लेकिन न्याय की आत्मा वही है। न्याय की आत्मा बदलने वाली नहीं है। समानता, पारदर्शिता और विनम्रता और समय पे न्याय की प्राप्ति, इसकी दरकार सदैव रहेगी। मेरी अपनी ओर से पुनः सबका वंदन, अभिनंदन, बहुत बहुत धन्यवाद।
Thank you, sir, for that insightful address, which inspired and guided us all. As we inch closer to the end of the inaugural session, I take pride in announcing that the High Court of Madhya Pradesh has devised some path-breaking technological innovations to advance the cause of justice. I request Honorable Mr. Justice Vivek Rusia, Administrative Judge, High Court of Madhya Pradesh, Bench at Indore, to please introduce these innovations.
Since we are running short of time, therefore, I may be judiciary, a commitment to modernization. Our commitment to an efficient, transparent, and modern justice delivery system is clear through the numerous IT and e-courts initiatives that we have successfully completed. We have ushered in an era of paperless court by completing the scanning of and digitization of a staggering volume of record, approximately 65.59 lakhs file at the High Court, which translates to over 23.67 crores pages. At the District Court, digitization of about 61.28 crores pages has been completed. This foundation is crucial for realizing a truly paperless court environment. Key initiatives like live streaming of the court proceeding, the initiation of e-courts services with Lok Seva Kendra, and implementation of online e-court fee system, e-certified copy, e-RTI, e-inspection of record, motor accidents claim calculator, and many more have been made justice more accessible and users-friendly. Furthermore, our infrastructure has been fortified with secure Wi-Fi network and installation of 2,361 video conferencing system across various courts, enabling a virtual hearing of cases. Today, we take another significant step forward by launching two new software applications that will further streamline our operations. First is online legal internship application software.